All right, welcome to another episode of Millennial Money Matters with your host, Derek Mazzarella. And you may notice, but Kelly Turner is absent. She is very sick with laryngitis, but filling in her place, we have a very special guest, Aaron Frankel from Franklin and Frankel. Welcome, Aaron.
Thanks for having me, Derek.
How you doing?
I'm doing well. How are you?
So this is Aaron's first podcast, so everyone needs to be very, very tender and caring with him. Okay?
Keep the comments constructive.
Okay. So, Aaron, what are we talking about today?
Talking about estate planning.
Estate planning. So Aaron is a estate planning attorney, and we're going to get into the nitty gritty of it. I get so many questions on it. Before we get into that, though, why don't you just give a little background on yourself and why you're qualified to talk to us today?
Sure. So I'm an attorney in West Hartford, Connecticut. My firm does estate planning. We do probate. We also work with business owners on a wide variety of business law stuff and on real estate. So we are day in and day out helping our clients get their estate plans in order, get them edited, get them updated, think about what the long-term plan is and how they want to protect assets for their clients. So it's a conversation we're having with people every day as their lives twist and turn and they want to protect.
Well, I mean, this has always been the hardest conversation I have with clients, not because I'm afraid to talk about dying. It's because they just don't do it. So I will go through a full financial plan with folks, and the hardest thing I have to getting to do is going to see someone like yourself, Aaron. So why don't we just get into a little bit, let's not make this scary, right? Because I don't think it has to be. What are the basic documents everyone should have?
Everyone needs a will. Some people need a trust. Everyone needs healthcare instructions, or you may have heard it called a living will. Mm-hmm. Everyone should give a power of attorney to someone. And if you have children, you should do a guardianship memorandum, which is sort of an addendum to your will that says who's going to take care of my kids if I die. Though that's the core. Those are the things we talk about in almost every single meeting.
All right. Why don't we just kind of go through each one and break them down a little bit more? All right. So a will is the way I kind of phrase like a wish list, right? This is what I kind of want to happen. How would you expand on that?
A will really is instructions. It's your detailed instructions that you're leaving to your heirs, to the probate court, and it says this is exactly what I want to happen with my stuff, my assets when I die, and this is who I want to carry out those instructions for me. Mm-hmm. So the will says, and typically we'll break it down into a couple categories, right? Like specific bequests, so whether it's things, items, my car, my firearms, my Picasso painting, whatever it is.
What kind of clients you work with?
Yeah, not that often. But you are leaving specific instructions on where those things go to, or it could be to a charity or to a person, whatever it is. You're leaving specific instructions on where your digital assets go to. So it could be files, it could be cryptocurrency, it could be, all that stuff. We say who those things are going to. And then we have this catch-all bucket called the rest, residue, and remainder.
Okay.
And that's everything else that we're not naming. You don't have to put a name, every single thing that you own.
You don't need to itemize every piece of jewelry you have or what have you.
And so that's the catch-all bucket. It's everything else. This is where it's going to. Mm-hmm. So that's one side of the will. And then we say who's going to carry out those instructions and what rules do they need to follow. And so we call that person the executor.
Executor, right.
And the executor, we're saying this is who I trust to do the job, and these are the things that these are the powers that I give to them to do it.
And I think one thing that's important too is the executor, especially if you have kids, doesn't always have to be the same person as the guardian.
No, the executor, I mean, we like it when people sort of divide up roles.
Yeah.
It's a little, when we talk about trusts in a second, we really like it when the trustee for a trust for the benefit of your children is different than the guardian.
Yeah.
We think about it as you're setting up your team. In the worst case scenario, if you're not around anymore, we want to make sure that multiple people who you trust have an eye on the best interest of your children, basically.
Right. Yeah, and there's some checks and balances there.
And then the one I think on the executor, there doesn't have to be expertise there. You're choosing a person who you believe will diligently file the documents you need, talk to your attorney who's helping settle the estate. It's just someone who kind of has to stay on top of the documents, the flow. And
so you're a responsible friend. You don't want,
Correct.
or a family member. You don't want, this is the responsibility tax.
Yeah, you don't need to go find your someone who has financial experience, but someone who's organized enough to get the job done.
Right, because you can theoretically pay for that, right? You could have an attorney be your executor, right? Or you could have a third party bank or institution be your executor if you like.
Yeah, we see that with executors. We see that with trustees also. Yeah. But I always say to people, who knows you?
Yep.
Who's going to know what you would want? and who's actually going to care to get this done for you, right? Like you want someone who cares about you enough to say like, I'm going to make sure I do this right.
Well, yeah, we had my grandfather passed away, but before that, his wife passed away because he remarried, and the attorney that they had was supposed to be their executor, but he was also on the way out. He was like pretty much retired, right. So he did nothing. So like that's it, to your point. Like you want to make sure you have someone in there that you can trust, you know, is going to be capable of doing it and is actually going to execute on your wishes.
Right. Yeah, that's the key.
Yeah. So all right, what about the other documents? We'll get into trust in a second, but let's talk about the health piece of it.
Yeah, I look at sort of like the power of attorney and the healthcare instructions, living will as two sides of the same coin. This is you're giving another person power to make decisions about you while you're still alive. That's the key, still alive. Yeah. So power of attorney is you're giving somebody else power to make legal decisions for you while you are living. So there's sort of two types of powers of attorney. There's like a general durable power of attorney. I give you my general durable power of attorney. Like today, you can take this document and go to a bank and say, okay, I'm going to go, open up a bank account on Aaron's behalf because I have this power of attorney. So it's a sensitive responsibility you're giving to somebody. But if you ever get sick, get in a car accident, whatever it is, you want to make sure that's in place beforehand because you can't give it once you are unconscious or not able to make that decision. Sometimes people like springing powers of attorney because those documents say that it doesn't come into effect until X event happens.
Okay. So what's the determining factor of that, or who determines that piece of it? Is that where it gets a little tricky though?
So that's why we don't always, I really don't advise people to get those unless there's a specific reason for it, because now now whoever it is that's trying to use that power of attorney has to like go find a doctor to sign off and say like this person is no longer capable of making this decision. And so it's an extra hurdle in what's already sort of a time sensitive situation.
Yeah, generally when you need the power of attorney to execute something, it's to either pay a bill that's like immediate, right, or it's some other kind of specific issue. Typically,
we had a business client who the husband owned a medical practice. He very quickly became sick. He had no estate plan, except he had given his wife power of attorney. And so at least she had the ability to start making arrangements to sell the practice because she had this document in hand. And if that didn't exist, like there would be no way. It would have been, the value of the practice could have gone down very quickly in his absence, with no one with authority to start making decisions for him.
I mean, think about it. Let's say because if you had no estate documents, it goes through probate, which we'll get into in a second, but it gets tied up in this court system for a while. How do you think that's going to impact the value of your business?
I mean, especially if you don't have, this goes down that whole rabbit hole of business estate planning, right? But it's like if there's no other person who can step in and keep the trains running while you are absent, then the value goes down significantly because, patients go elsewhere, customers go elsewhere. If, orders aren't being filled, appointments aren't being made.
Right. Now, in terms of guardianship, is there anything you should really watch out for in terms of, other than choosing someone that's responsible or that you think would care for your kids? Is there anything like red flags to watch out for, or anything people should be aware of? Is it pretty straightforward?
People are always thinking about a couple things, right? Like, who do I trust to take care of my kids? Yeah. But it's also like what stage of life is your child at, right? Like it's a different decision for your 2-year-old than it is for your 16-year-old, right? Like your 2-year-old, it may not be such an interruption for them to move to another state. If the guardian that you desire to take care of your kids lives in another state, their life is, obviously their life is already interrupted, but not as much. Right. But your 16-year-olds, like they're in school. This is their home that they live in. Their friends are here. So the right guardian for your 16-year-old is different than for your 2-year-old. And so we talk to clients about the plan you're making is for now, for your 2-year-old, but let's revisit this when you have a 7-year-old or when you have a 10-year-old. You may want to change who you've designated as a guardian for your child. That's
a great point. And, I think that brings up another point is this is not like, I do it once and the box is checked and now I move forward for the rest of my life. Your wills need to be updated over time because, tax laws change, your life changes, you may move. There's a whole host of reasons, or you may have a major life event, whether someone dies or you have a new child come into your life, anything like that, adoption. So what are the trigger events where you would update your will, or how often should you typically at least look at it?
So I was just telling a client about this yesterday. You look at it every year. Think does this still make sense for me? Does this still reflect my life? Are these still the people I trust and want to turn to? there are so there's sort of milestones where we see people, right? It's like you have kids. That's when we see a lot of people, right? Because now that's a reason to get this done.
I'm an adult now.
If now your kids are a little bit older, maybe you've moved, maybe your parents were originally the people who you designated to be, whether it's like executors or guardians, maybe they're aging now and you don't think that they're the right fit to be the long-term guardian for your child anymore.
Right.
Maybe you've had a change in relationship with someone who you've designated as a beneficiary, someone who's inheriting your stuff, or as an executor, someone who's going to take care of your estate. That's another reason to update things. Moving to a different state, you might consider changing documents to match that state's laws. Like laws are different in every state.
Yeah.
And then as people age, their children are getting to be grown. Maybe they don't need a trust, or maybe they need a different kind of trust. Maybe as their children get older, now those are the people they want to list as their executor, and change all that stuff around. And then as aging even more, right, we start to talk about Medicaid planning and long-term care. So those are all, those are typical periods where people think about updating their will. But it's worth just remembering, what did I set up every year?
Yeah, exactly. Now, in terms of one of the questions I get asked is, okay, like I've got these beneficiaries, right? Because I think a lot of people miss the real low-hanging fruit with estate planning. It's your beneficiaries, like your 401k, life insurance, even your bank accounts or investment accounts. They could all be titled, like either a transfer on death or a joint, or in case of IRAs and 401ks, they're going to have beneficiaries tied to them. So like to me, that's estate planning. And that's something that, is going to supersede the will anyway. Most people don't understand that. Well, my will says this, but yeah, your ex-wife is still on the beneficiary, so she's getting the money. Sorry, pal. At what point, I think what's the danger of having a under 18 child get, whatever stuff as a beneficiary?
Yeah, I mean, it goes back to, and like maybe we should just talk about what is probate and like
why don't we get into probate first, and maybe we can touch on that.
Well, so I mean, in that situation, like under 18-year-olds can't inherit outright. So like now you've got state law that dictates someone has to come in and manage that money from them, and like who's deciding who that someone's going to be? Well, it's a probate court, and that's the case for all. And so like, it's fine. We have a process to say who that person becomes, but it's not the person you chose if you didn't choose anybody. So
even if the will says, okay, I want this person to be the executor.
That's so I guess those are two separate questions, right? Because the will can say, I want this person to be the executor, but if the will says I'm leaving my money to my 5-year-old and you don't have a trust set up for the 5-year-old, a probate court's going to come in and say, who is the person who's going to be managing the money for your 5-year-old? That's why we like revocable or living trusts for people who have minor children. It gives you a mechanism. It's a separate document. It's a contract between you and yourself and the trustee, who it puts guardrails around who's going to take care of your money for your kids if you pass. What are the rules that they have to follow? When do your kids get to inherit that money outright? And how is it going to be used for your kids' benefit? Without that stuff, so like without a will, the probate court is going to use state law to say who inherits your money. And
how do they determine that? Is that typically like
there's a statute?
Is it uncle, or is it?
There's a statute that there's basically like an order of operations. It's like if you're single and no kids, like the money goes to your parents. Like this is not a verbatim recitation, but it basically sounds something like if you have a spouse and no kids, everything except for everything except for $100,000 and 3/4 of what's left goes to your spouse, but then your parents get some of it, right?
Yeah.
It's like maybe you don't want your parents to get some of it. Like if you don't have parents and no spouse, like just goes to all your siblings. If you have kids, there is an order of operations that the statute says you have to follow, and you may not want to follow that order of operations.
Right. Yeah, that makes sense. Okay. Well, all right. Why don't we get into trust then? Because to me, that's a question I get asked a lot as a financial planner. What are the types of trust? And I feel like the comment I get is like, oh, I'm not a wealthy person. I'm not like Elon Musk here. Like, why would I ever need a trust? Like, that's for rich people.
Yeah, trusts are for everyone. They can be not for everyone. They're for many people.
Yeah.
Trusts for people with minor children. A revocable trust, a trust that you can put stuff, the grantor. I'm the person who's putting the money in. I'm the grantor.
Yeah.
You can put stuff in and you can take it out while you're alive.
Yeah.
You have all the control over it while you're alive. But it's a thing that's in place that creates a long-term structure for your children's money to be taken care of if you and your spouse die. So anyone with minor children should strongly consider having a trust, because for that reason, kids can't inherit money. People who want to avoid probate, people who want to give assets to another person without first having to wait for the probate court to get involved, may want to use trust. So for instance, if you are getting older, you want your child to have your house, right?
Yeah.
Or maybe your child's already living in a house that you own, or they live there with you. You don't want to have to wait for an executor to be appointed by the probate court for the house to become your child. You could put the house into the name of your trust. The trust document says that upon my death, the house becomes my child's house. There's no probate court involvement. There's no waiting for an executor to be appointed. It's just the separate contract that dictates how the asset is passing. There's also this whole other thing called an irrevocable trust. So like try to get people to say that word back to you.
Yeah.
Practice it, like irrevocable. An irrevocable trust is a different planning tool. That tool, or different flavors of that tool, get used for a lot of times for people who want to qualify for state aid, different types. So we see it with people with children with special needs.
Yep.
Want to leave their kids money, but don't want to jeopardize their kids' ability to qualify for state aid down the road. Or maybe they just don't want they want their kids to have money, but they don't want them to have the full amount outright. There are different flavors of supplemental needs or special needs trusts we would set up there. And then there's Medicaid planning for elderly folks. Like, I don't think people realize until they really get into it how expensive long-term care is.
Yeah, well, this is a question I get asked all the time. It's like, okay, how do I hide my assets for probate? Not that we have to get into this right now, but I'm like, to me, that's a whole different conversation, because like now you're saying, okay, I want the state to be in charge of my care. Right.
Yeah, and so people are, when the state looks at your eligibility to qualify for some type of Medicaid for long-term care, they look at they look back 5 years.
Yeah. And
so they see like what's in your name. Well, your house, for a lot of people, house is the biggest asset. And so the value of the house is going to count against you. And everyone's heard about like the spend down, right?
Yep.
And there are guardrails around like, can the state actually kick you out of your house while you're living? But certainly if that's an asset you want to pass along to your children, or the value of it, people consider putting assets into an irrevocable trust. It's no longer your house anymore, but you get to keep the value of it and then pass it along to your kids or your beneficiaries.
Yeah, well, so I'm going to use an analogy here, and you tell me if this is way off, because this is one I use all the time, so I may be totally wrong in this. But when looking at the two different types of trust, the revocable one it's mostly like about control, right, of the assets. You retain control when you have a revocable trust. So think of it like, I own a car. I want to let Aaron borrow it. He's going to drive it. Here's the keys, but I still have the title of it. I still pay the insurance. I technically own it, and I say, hey, Aaron, give me the keys back when you're done, right? An irrevocable trust says, all right, I'm giving up the keys. I have no title anymore. It's like now the trust is the owner of the car. They can probably let me use it based on the stipulations of the trust. Did I do that correctly?
Yeah, the irrevocable. It's like we make the rules so that the person who used to own the car, has a right to use it for as long as you're alive.
Right.
You might have the right to change who the trustee is, the person who's now managing the car, as long as you're never that person.
Right.
You could probably even change the beneficiaries as long as you're never going to be the beneficiary, but that's never going to be your car.
Yeah.
And if the trust sells that car, you're never getting the money from that sale.
Yeah, so it's a very permanent solution. And I think it was probably a little bit more popular when the estate tax limits were much lower. Now they're obscenely high. Like, not the average person is not running that issue.
So when we're talking to Massachusetts clients,
yeah,
the cap, the exemption for gift tax, so in other words, the amount of gift you can give to somebody else without getting hit with estate taxes is only $2 million in Mass,
which is almost a house now.
Right. In Connecticut, it follows the federal exemption, which is I think about to be $15 million.
Yeah, close to that. Yeah,
or 14
per person. So you as a couple, $30 million you're looking at basically before you have to worry about that.
Yeah, so it's less of in Connecticut. It's not, the answer is not every single person needs a trust to avoid paying gift taxes because of that high exemption. In Massachusetts, it's a different conversation.
Right. So yeah, everything's state specific. That's why it pays to talk to a professional like yourself, Aaron, to go through that. All right, so walk me through, like, what's the challenge of, like, everyone is afraid of probate. Like, what's the real downside of probate when you've got all your ducks in a row? Is like, what does it look like? Is it a long process? Is it expensive? I think it's like this boogeyman that people just don't understand. Can you just kind of walk me through what the probate process is like?
Yeah, I mean, it's like, for 1 second to back up, like, what's the point of the probate court? Is it just like to hassle you and put hurdles in your way? No, the probate court is there to make sure that, like, your stuff goes where you want it to go to. There's some third party that's validating, right,
Yeah.
This is what you wanted. We're going to make sure that it actually happens. So there's a reason why it exists. The probate court, when you die, someone submits your death certificate to the probate court to prove you died, and your will to show like, these were their wishes. The probate court's going to take some time. They're going to look at that. It might take like a week or two. Once that has been basically accepted, the probate court has noted it, accepted it. Now your executor is appointed. Yep. And now that person has authority to start doing stuff according to your wishes, basically. So that's the delay, right? Like you're waiting for them to get the will entered and accepted, and it's going to take a little bit of time, but it's not a horrible process, right?
Yeah, you're not going to be tied up for 6 years, right?
Right. When you hear about things getting tied up for really, and so now there are different steps. Like we submit a form that shows like what your individually owned assets versus what your jointly owned assets are. That's for the probate court to see like what assets are actually subject to your will versus what assets are not subject to your will. So like you touched on investment accounts and IRAs and all that stuff. All those things, if they have designated beneficiaries on them, are not subject to the will. But things like bank accounts where just your name is on them, those are going to be subject to the will. The house, if it's not in two people's name, right?
Right.
People get, a bit annoyed about, like the house. Maybe it's like another hurdle if you have to sell your house. If it's subject to a probate estate, basically. But it just means that the executor has to sign off on the deed ultimately when the sale is done. So again, not the end of the world. It can be done pretty smoothly. It's things like, businesses, a sale of a business or an interest in a business, things that take a long time independently that then cause the probate court and the probate process to be open for a long time because now you need the probate court to sign off on like the sale of your business, or you need the probate court to, basically they're watching over what's being done with those assets. Those are the things that cause estates to go on for longer. In Connecticut, everyone goes to probate, right? Like even if you think that you have set up your estate in such a way that there's no need for probate court to be involved.
So let's say you have, I just want to make sure I'm clear, you have everything in a trust or you have a beneficiary. You still can go through probate.
The probate court still is going to get their fee on the value of everything in your estate, even if it's not a probate asset. So like that form that you are required to put in that says, you could have $100 million in your estate, all of it in 401ks, IRAs. You're going to pay your probate fee based on the $100 million, even if it's not. Now the probate fee is not like estate taxes. Like we're talking about, typically it's gonna be somewhere between like $5,000 and $10,000 at like the high end. Right?
Okay, so
it's not a
percent.
huge.
It's not it's 3%.
It's not like you're paying estate tax or something like that. But yeah, so there is really no way to avoid probate altogether. It's just a matter of setting things up in such a way that the probate process is efficient, short, predictable, and easy for your executor and your beneficiaries to navigate.
I mean, to me, that's like one of the best gifts you give your family members is like, hey, I'm not going to leave you a pile of crap to deal with. Right. I'm gonna leave you a nice, smooth process that'll take a few months tops, right?
And that's another reason why people come in to do estate planning who never had a will or anything is because they just settled mom's estate and it was a nightmare because she had no will, and now they're like, I do not want that for my children. I've dragged my feet on this for decades, but now I see the gift it is to give to my kids to have things set up and predictable.
Well, it just provides so much clarity, first of all, and I've seen it with my own family, and I've seen it, throughout my job. Like the amount of, it's like people get really funny when money is involved. And when there's no clear direction of who's getting what and when and how much and all that stuff, it gets really dicey and it can tear families apart. People are like, oh, not my kids. Bull. Like that is going to happen. And one of the best ways you can keep that family unit together after you're gone is to put these documents in place, because that's important.
Absolutely. Yeah. I mean, we say, we send this intake form out to our clients before they come in for our initial meeting, right? And we ask them to give us all these answers about what they want, what their wishes are, financial information, whatever. And the biggest benefit of that, in addition to giving us the information we need ahead of time, is to get the conversation started. These are not easy conversations to have, right?
No, but definitely not. Yeah.
But if no one ever forced you to sit down and talk to your kids about like, hey, this is what I'm thinking. Like, is this house something you want to keep in the family? This is what we're thinking about as far as like who's going to make decisions for us. If you never have that conversation, it's a lot harder when like someone's already died and you're in a place of grief and distress, and emotions are high and siblings are, no longer getting along. Right. And if you gave your children the gift of having had the conversation ahead of time, telling them what your thoughts and wishes are and getting their input, or at least telling them ahead of time, like, this is what's coming, it goes a long way towards making the process a lot less contentious.
Yeah.
In that position of distress.
Right. Because I think you're spot on. I think we have this taboo thing about money, like, oh, I don't want my kids to know how much I have, and they'll figure it out, and it's going to be in the documents anyway. I just think it's avoids a lot of challenges down the line when people know ahead of time. Okay, this is the plan. This is what we're doing. This is why I'm doing it. And family dynamics are so different. Like, there may be one family that, like, all right, I took care of mom for 6 years. You lived in another state. Like, I deserve more money. Blah blah blah. Or this person is too into drugs, and we need to put a trust up there to make sure they don't get all the money right away because they'll blow it on whatever. So all of those things are really important to consider, and the dynamics can be so different from family to family.
Yeah, it's we see every flavor of it. The more you can think about it, we will always ask, like, is there someone who thinks that they stand to inherit something on your will who is going to be surprised if they don't, right?
Yeah, such a good question.
We just want to think about it ahead of time. We want to think about what might be coming, because the more that we can sort of address those things head on, the better the outcome is going to be when the time comes.
Yeah. I know it's all fun conversation talking about dying. Now, I know you do some work with some business owners too. So, all right, let's talk about LLCs. Like, I feel like I get a lot of questions on this too. The biggest one, I think TikTok's like, oh, just set up an LLC, you save taxes. Like, nope, that is not what an LLC is for. So what is an LLC? What is it for? And why would you set one up?
LLC is it's called a limited liability company.
Yeah.
So it's for limited liability. Mm-hmm. If you set up an LLC correctly and you operate your LLC like an actual business and not just an extension of yourself, and I'll talk about what that is. Yeah. You should have limited liability, which means if someone sues you, if you have creditors, if you have slip and fall at your commercial building, whatever it is, that person, that creditor, that claimant against you should be limited in their recovery to the assets of your LLC, not your personal assets. So, you buy an investment property, you put that investment property into an LLC, someone slips and falls on the front steps, like, they can only sue you for the value of the investment property and not all of your other personal assets. How do you make sure you protect that? Well, you make sure you have a business bank account. You only spend your business expenses using the business bank account and not your personal checking account or whatever it is.
They call it commingling
assets, right? You do the basic formalities that show you're an actual LLC, like you have an operating agreement, and we'll talk about more about that in a second. You have your annual meeting, and it sounds silly, but it's like, even if you're a single member LLC, it just makes sense to document, these are the decisions we made this year. I put money into my simple IRA or my self-direct, whatever it is. Yeah. Just put it down. It just shows, if a court is ever scrutinizing you and whether you're entitled to limited liability, you're going to put those things forward and say, like, look, this is what the law says that a LLC like us should do, and we do it. It takes 10 minutes per year. Your lawyer can do it. You could do it. That's stuff that gets you limited liability. And it's one of those things. It's like, you don't think about it until you need it.
Yeah, and you don't want to be in a position where you do need it.
Correct.
And it's too late. You don't have it.
Right.
All right. Any final, like, quick tips, or, all right, let's say I'm all right. Anything that we should be aware of beyond, like, anything we just discussed
on the LLC side? Like, one other thing. So, like, business owners, like, the LLC, the operating agreement, which is like the rules of how you run your company, that is also estate planning, right? Because if you own a business, especially if you own a business with another person, that might be one of your largest assets, is your share of that business. You can use your operating agreement to make rules about what happens to your ownership share if something happens to you, whether you're disabled or you die or you just want to leave the business, right? Yeah. The operating agreement is a way to plan ahead for those things. So just like with the other estate planning documents, you're not in a fight. You're not in an uncertain situation about what happens to this major asset that I have in the event that something happens to me. And
like the buy-sell agreement, right? You're talking
correct,
about
buy-sell agreement. So it's, in other words, it's like, if I die, this is what the price is that my other owner is going to buy out my estate for. Like, that's how you make sure your estate actually gets money from the business that you've built if you die. You can have insurance to cover your share of the life insurance to cover your share of the business. You can have disability insurance to cover, like, the buyout if you become disabled and you're no longer able to do the work. Those are all ways that that's estate planning too, right?
Yeah.
You know, some people decide as they get closer to retirement, as they age, they want to have their share of their business owned by a trust. And so that means just like whatever that share of the business, if you die, just automatically goes into your what was a revocable trust until you died, basically. It's estate planning too, and business owners really need to think about how their business interests play into the whole.
Yeah, I think that's incredibly important. And I think a lot of them, because I've read a few, and they don't talk about disability either. And to me, that's a harder one because when you die, you're dead. There's no like gray area with that, right? With disability, it could be like, okay, well, this person's gonna be out 2 months, 6 months, a year, 2 years. Like, at what point you're like, hey, pal, like I can't run this business without you. I need to hire someone, or I need funds from you. So there could be a lot of issues that come up, especially with those buy sell issues that are saying, okay, well, like what's the funding mechanism for that? Like, do you have enough business cash available to buy the other person out? Like, do you want your spouse, your partner's spouse, to be the co-owner? Because that's essentially what's going to happen right away. And they're most likely not interested at all in running the business, nor are they qualified. And they may not have the money to do that. So it's really important to kind of vet through those things, especially if you have a partnership or anything.
Yeah, it's just you don't have to cover every contingency, and this is sort of like the thing that people get bogged down in across all estate planning, right? Like we give them these questions like, well, what if your whole family is gone? Like, who do you want to get your money? It's like, let's not get bogged down in these. Yeah. Let's not let this stop us from getting to a plan.
Right.
We make the best decision we can in the moment.
Yeah.
We can always adjust it, but like let's not let one contingency or the fact that we don't exactly know what we want to happen in this scenario stop us from making you a plan that's going to protect you in 99% of the scenarios that might happen.
Because like we always adjust along the way anyway, right. And makes sense. All right, so get back. Did I miss anything else on the LLCs before we move on? Is that
No, I don't think so. It's just
okay.
We just want owners to know of businesses that like that's part of, you got to plan for that too.
For sure. And then so any like last minute tips or anything? Like one thing I always kind of tell, like if you own a house and one spouse dies, like you should get a step up in basis on the house, like get a valuation of the house so you have the value of the house at the death. Like any other kind of quick tips or anything we should kind of be aware of to set yourself up?
Yeah, I mean, if you're working with an advisor, it's like, you're talking to them about making sure your beneficiaries are the right people. And like that's, if you're changing your will around, like that doesn't affect who your beneficiaries are under those IRAs, life insurance, whatever it is. So pay attention to that. Just check in every year. It doesn't have to be complicated. It doesn't have to be time. Just look at the document. When we send like a will out to like our estate plan out to people, we give them a little summary of like, this is what every document says.
Yeah.
Just check that and remind yourself whether this is something that you actually want or not. But the thing that, if it feels like too much, if it feels like the decisions are too big to kind of get over the hump to doing the estate plan, just remember it's not set in stone.
Right.
This is a plan for right now. It can change. Once you've done it one time, it's easier to go back and change it the second time. It can change. It will evolve. It'll change with your life. Don't let that perfect scenario, like a perfectly having all the scenarios thought about, stop you from just getting started.
Yeah, getting it done is better than getting it perfect.
Correct.
And then I guess one last question on the digital asset piece, because I feel like we haven't really talked about it, but I think it's becoming a bigger and bigger part of the estate plan. Like, is there, like, what's some like red flags to watch over? Like, things I have is like, okay, like maybe I have a Face ID in my phone and I can't get the multi-factor identification. Like, what are ways around that? Like, how do you protect yourself? Like, how do you make a plan for like the digital asset piece?
Yeah, that's a hard one. I've seen online products as far as like either online or on paper, just a place where you list off all of your assets. Like, this is where my money is. These are my passwords, all that. I mean, I just think about this in my personal life. Like, how do I communicate to my wife, like where all my accounts are? Basically, I've got a list. I mean, like by accounts, I mean like this is the password to this bank or whatever. Yeah. I try to keep a list of like where our money is. The passwords change, but there is a process if someone dies to go to that institution and just say like, here's the death certificate. Like I need access to this account. At least pass along to your loved ones. Like this is where my money is. This is where my sensitive documents are. It's just some extra homework, but I think it goes a long way towards making things easier for your people.
Yeah, my wife gets mad at me every time